Good morning and welcome to Advocation's May webinar, a primer on workplace laws. And thank you everyone who's online and joining us today. For those of you who haven't attended a webinar or aren't familiar with me, I am Hermie Abraham, and I am a lawyer with Advocation Professional Corporation. Prior to being a lawyer, I was a human resources professional. And part of Training Thursday was born out of the need to provide accessible information about employment laws that impact workplaces in easy to use, easy to find manner. Oftentimes, organizations don't have the benefit of a dedicated human resources professional or a in-house counsel. So these webinars are to enable you to have some information about the laws that apply to you and be able to ask some of your questions. In terms of Training Thursdays, they are held on the third Thursday of each month at 9:00 a.m. and they last for approximately 30 minutes. And there's a new topic for each month, so please be sure to register so you are kept apprised. And I am looking for your feedback on the type of topics that you would like to see. I've provided some topics for the year, but I'm always open to hearing what you'd like to hear, the hot button topics within your workplace. So I've provided an email address. Do let me know. A few housekeeping issues before we get started with the webinar. We're using a Google Hangout platform, and there tends to be a delay from time to time, especially if I'm doing polling and also with questions. So I do ask that you put your questions in well in advance so I have an opportunity to review them and answer them. As well, if you pause the webinar, you will be able to pick up from where you left off, but you will not be live anymore. So understand that that's going to affect your ability to participate in a live format. And again, like I said, I will be taking questions at the end, so please do submit your questions as soon as they come to you, so there's plenty of time for which to answer them. And with that, I will get started. So the topic today is a primer on workplace laws. And the reason I chose this topic was because there's often confusion about which laws apply within a workplace. And the thought process in putting this webinar together is to look at some of the overall main laws that apply within a workplace for employers. So today what we're going to be going over are the main Ontario labor and employment laws that impact your workplace. And you'll find that we're looking at private sector workplaces, not necessarily public sector. And of course, we only have 30 minutes today, so it's not meant to canvass and be able to cover every single workplace law, but just the main ones that impact. And it's important to also know that there are some specific laws based on industry or position. So for example, if you are an agricultural worker, you would have protections under the Agricultural Employees Protection Act. Or if you are working in an accounting firm, you would be also subject to the Chartered Accountant Act. Obviously, we can't go into all of those individual acts. If you have questions about which acts might apply to you, please do submit a comment to me. Let me know about your workplace. I'd be happy to provide you with some guidance. Also, we're not going to be reviewing federal laws today. There are a number of federally regulated employers, only 6% of the total Canadian workplace. I know that there are some people on the webinar today who are federally regulated. And unfortunately, we're not going to be looking at federal laws, but if it's something that you're interested in, please do let me know, and we'll make sure that we cover it off in a future webinar. So the first thing I want to do is talk about the types of laws that apply within the workplace. And they can be broken up in two main types of laws, statutory and common law. And statutory laws are the laws that we will be reviewing today. So we know them as the written laws that are enacted by government or legislature. And these are prescriptive, meaning that employers are required to follow and comply with the directives that are set out in the law. And these laws are not static, they do evolve. So oftentimes we'll see new laws that are introduced. For example, the Accessibility for Ontarians with Disabilities Act. That was a new law that was enacted in 2005. It does have a legacy law that it came from, but essentially it was a new law for many workplaces. So that's an example of a new statutory law. And often what you see more often is amendments to statutory laws. And one area of law that we'll look at is the Occupational Health and Safety Act. And there have been a number of amendments over the last 5 years or so, and we'll talk about a few of them today. Another type of law that applies in the workplace is called the common law. And this is judge-made law that comes from judges or arbitration decisions, and it's instructive. So for example, recently there was a ruling about miscarriages being disabilities under the Human Rights Code. If you were to look at the written Human Rights Code, you're not going to see miscarriage listed as a disability. But that particular decision basically provides context or greater instruction on how we should interpret the statutory law. So common laws are actually also very important. Common law itself actually creates some legal duties that are unwritten but still apply to the workplace contract. For example, an employee has a common law duty of loyalty, fidelity, and to act in the best interest of the employer. And an employer has a duty to employees of fairness and fair dealing and to treat employees with respect. And again, you're not going to see these common laws written anywhere, but they do form part of the employment contract. And with the common law, it evolves as new decisions are made and judges and arbitrators render decisions. Now, the next thing we're going to look at are what I call the workplace standard laws. And I'm going to load a poll, so please do chime in and vote now if you have an opportunity. I will be ending the poll eventually, but please do vote now. The first laws we're going to look at are within workplace standards is the Employment Standards Act, and this is the main law that you tend to find applies to most workplaces. So the purpose of the Employment Standards Act is to establish minimum employer obligation and employee rights, and they touch on areas such as minimum wage, hours of work and overtime, vacations, holidays, employee leaves, and much more. As far as the application of the Employment Standards Act, it applies to most workplaces in Ontario that are provincially regulated. Now, you will find that there are some exceptions to industries within the law. So, for example, there's a regulation within the Employment Standards Act that says that construction workers are not they're not able to obtain the protections under termination notice provisions that are in the Employment Standards Act. So the regulation creates an exception for construction workers with that particular provision, but construction workers would still be covered for some of the other standards such as hours of work or overtime and vacation. I will be delving deeper into the employment standards laws in the July webinar. And in that particular webinar, we'll be looking at some of the common areas of violations and some of the legal requirements employers are required to follow within their workplace in terms of posting requirements and even some of the legislative changes that are coming up with the Employment Standards Act. So if that is of interest to you, again, please register and we will cover those topics in detail there. Now, the Employment Standards Act can be enforced in two ways: through a complaints process where an employee would complain and the Ministry of Labor would investigate, and through proactive inspections. And the ministry often has these blitzes. We're in the midst of a blitz right now. The blitz that's currently ongoing is one that runs until the end of June, and it targets workplaces that hire temporary foreign workers or young workers. And again, the ministry is looking to see if there are any violations and to ensure that employers are complying with the law. In September and October, the ministry will be doing another proactive inspection blitz of workplaces that have been repeat offenders. So these are workplaces that have had ministry complaints before or rulings where they're checking to ensure that there's ongoing compliance. So the poll was whether employers who violate the Employment Standards Act could face fines of up to $50,000, fines of up to $500,000, imprisonment, or all of the above? And obviously that we have some very knowledgeable people on the call, because you are correct that all of the above is the answer. Employers can face imprisonment of up to 12 months if there is a conviction of offense, and that's for individuals who employ people, as well as directors of corporations who are personally liable for violations. The next law that I'm going to look at is the Labor Relations Act. And the purpose of the Labor Relations Act is to set standards on union certification and decertification, the negotiation of a collective agreement. Operations of collective agreements, to a certain extent, are also managed by the legislation. And in Ontario, as far as private sector organizations are concerned, only 16% are unionized. So most likely, for a number of you on this call, the Labor Relations Act does not apply to you. Now, it says it applies to all the slide says it applies to all unionized workplaces in Ontario. It really should read most unionized workplaces, because there are some Ontario employees who are unionized but are excluded from the Labor Relations Act, and they would be federally regulated employees, so employees who work for banks or who work for telecommunication companies. Their regulations fall under the Canada Labour Code. And as well, there are some employees who are covered by their own special collective bargaining legislation, such as police, teachers, some Crown employees, hospital workers, nursing home workers, to name a few. So with the Labor Relations Act, if there is a violation, either the union or management can bring an unfair labor practice complaint in front of the Ontario Labor Relations Board. And they have a number of remedies, which include monetary compensation, specific performance in sort of requiring a union or employer to do something, or making declarations. So they can declare, let's say, a need to put a poster up, or for employer to communicate something to employees. So there are some broad enforcement and penalties under the Ontario Labor Relations Act. So that's what I'm going to look at as far as employment standards legislations are concerned, or workplace standards legislation. Now I want to delve into some of the employee rights legislation that applies to your workplace. And the first is the Human Rights Code, which is I guess, most common employee rights legislation that most employers deal with. Now, I've loaded a poll as well. Non-employees can start a complaint against an employer alleging an employment and human rights violation. So please do answer the poll, and we'll take it up in the end to see how you do. Now, the purpose of the Ontario Human Rights Code is to prohibit discrimination and harassment based specifically on protected grounds and in protected social areas. And the protected areas are employment. Employment is one. However, it's worth noting that human rights applies also to other areas, other protected areas, such as accommodation. So if you are providing housing, there would be human rights obligations there as well too. Or if you're providing goods and services, you would also be bound by the Human Rights Code in terms of ensuring that you don't discriminate or harass in your provision of services. The other important distinction with respects to the Human Rights Code is that it is based on enumerated grounds. So even though there might be discrimination or harassment within the workplace, or I would say discrimination more, maybe not so much harassment, but discrimination within the workplace where people are treated differently, it only becomes a code violation if it's based on that discrimination is based on a protected ground. And we know of some of these protected grounds. For example, age, ethnic origin, disability, gender identity and expression. There are a number of protected grounds. The June webinar, so the next webinar I'll be hosting, is meant to understand your obligations under the human rights laws. And so we'll delve a lot deeper into the protected grounds, and as well talk about employers' duty to accommodate and how employers can sort of discharge that duty to accommodate to ensure that you're meeting the needs under the code. So again, if that's something of interest to you, definitely please do register. Now, in terms of where the code applies, it applies to all Ontario employees and employers. So if you are federally regulated, you would still, and you are in the private sector, you would still be, and in the public sector, unless you're a federally regulated federal employee, but federally regulated workplaces such as banks or telecommunications would still have to comply with the Human Rights Code. And the answer to the question with a poll, can a non-employee start a complaint against employer? The answer is, in fact, true. So in certain circumstances, there might be somebody who is applying for a job. They're not yet an employee. They would still have the protections of the Human Rights Code. And if they felt that there was discrimination or harassment in a job interview or in non-selection of their particular application, then they could bring a human rights code even though they don't have an affiliation with the workplace. The other thing to note about the Human Rights Code is the person who can be a complainant doesn't necessarily have to be the person who's suffering from the abuse or suffering from the harassment. Somebody can bring forward a human rights complaint if they see discrimination or harassment taking place. So there could be external people to the workplace who might be able to make a complaint if they believe that that is there's a violation under the law. So the majority of people said false, that the answer, in fact, is true. Now, with respects to the enforcement of the Human Rights Code, the tribunal has large remedies in terms of what it can do. The biggest thing that they do is financial compensation, which is often called damages. And what they can do is provide any type of lost income or benefits that a person might have suffered as a result of the discrimination. And then they can also award for injury to dignity and feelings. And those general damages generally range between $5,000 and $15,000. However, most recently, last year, there was a case where two Ontario employees were awarded $200,000 cumulatively. And so that was the largest human rights award that was given. And I think there is a trend to put more teeth behind the legislation and provide higher awards for damages that employees suffer. Now, in that particular case, it was very egregious, but we are seeing a trend towards higher human rights damages. The tribunal can also provide non-financial measures such as reinstatement of an employee who has lost their job, or even a promotion or offer of employment to somebody who didn't get that promotion or offer of employment because of discrimination or harassment. And there's also a number of public interest remedies such as providing training or some kind of workplace declaration in terms of a policy about the rights within a workplace. The next law I'm going to look at is the Accessibility for Ontarians with Disabilities Act. This law came into effect in 2005. But it's not until 2012 that we're starting to see some of the standards come into effect. And the purpose of the Accessibility for Ontarians with Disability Act is to remove and prevent barriers to accessibility in Ontario. And there are many standards that AODA applies to, employment being one of those standards. And it should be known that AODA uses the same definition as disability, for disability as the Human Rights Code does. So it includes both visible disabilities and non-visible disabilities, such as some kind of developmental disability or mental health issue. Now, again, because AODA is becoming a hot area with compliance requirements for employers, I have set a separate webinar to address it, so we could spend 30 minutes just to discuss that legislation. And that is taking place in August. So again, if you are interested in AODA, definitely register. With respects to the application of AODA, it has been based on the size of the organization. So right now, all organizations, even if you have one employee, you're required to have a workplace emergency plan for employees with disabilities. You're required to have customer service policies if they apply with respects to the delivery of your services. And you should have trained your staff and volunteers on your policies and your program for people with disabilities. For workplaces with 50 or more employees, there have been greater requirements, and these are going to be also rolled out into smaller workplaces eventually. Some of the requirements for these larger workplaces are filing an accessibility compliance report. So there's an online filing system that should have been completed in December of 2014. There was a requirement to do so again in 2017. And as of January of this year, employers with employees with disabilities were required to have individual accommodation plans, a return to work process, including the type of accommodation that might be necessary, and recruitment and selection information. So job applicants know about the accommodations that your organization provides if they ask for it through the hiring process. So those are in law right now that you should have if you have 50 or more employees. If you have less than 50 employees, those particular provisions are going to come into law in 2017. And again, like I said, our August webinar will discuss the Ontario Accessibility for Ontarians with Disability Act. The last piece of legislation under employee rights that I want to look at is pay equity. And pay equity is one of those areas that people have a lot of questions, and there is a bit of confusion on how it works. So the purpose of pay equity is to ensure that employees receive equal pay for work of equal value. Now, I've put a poll up. Does the Pay Equity Act ensure that if a man and a woman are doing the same job, they must receive the same pay? So if you can go ahead and answer that question now, that would be great. Now, with pay equity, employers are required to identify and correct gender discrimination in their pay practices. And how they do this is by analyzing job classes, adjusting the wages of employees so that people in comparable job classes are provided with the same compensation based on skill, effort, responsibility, working conditions, etc. And it applies to workplaces, all workplaces, and private sector employees with less than 10 employees are not required to comply with pay equity. So all workplaces except for private sector employers with less than 10 employees. Now, the answer to the poll question, whether the Pay Equity Act ensures that if a man and women are doing the same job, they must receive the same pay, the answer is in fact false. So pay equity is not about equal pay for the same work. That's actually addressed by the Human Rights Code. But pay equity is about ensuring that similar jobs are going to be compensated in the same manner. So if there's a secretarial work and there's another that tends to be populated by women, and there's another administrative type work, let's say like a superintendent, that tends to be done by by men generally, you would expect to see that there will be a parity in the pay within those two types of job classes if they are similar and comparable. And with respects to pay equity, I will say this, that there's been very little enforcement of pay equity. That might change in future, but it's really just based on complaints and investigations that are done by the Pay Equity Commission. Now, I'm going to look at the two workplace laws. I'm seeing that we're coming close to the time, but we'll go through the workplace laws and we'll talk a little bit about employee privacy. So the two workplace safety laws that I want to look at are the Occupational Health and Safety Act and the Workplace Safety and Insurance Act. And I do have a poll for the Occupational Health and Safety Act. So if you can go ahead and answer that. The purpose of the Occupational Health and Safety Act is to protect workers from health and safety hazards on the job. And it also establishes procedures for dealing with workplace hazards. It gives workers three important rights. The first is the right to know about workplace hazards. The second is the right to participate in identifying and solving workplace health and safety problems. And the third is the right of workers to be able to refuse unsafe work. Now, in past, the Occupational Health and Safety Act has taken a far more, I would say, traditional view of health and safety violations, so in that it looked at unsafe work in construction or manufacturing, or dealing with hazardous materials. As of late, the Health and Safety Act has taken a much more broad definition of workplace safety, and we've seen that in Bill 168, which came into effect in June 2010, which dealt with workplace violence and harassment, and also include workplace bullying and also domestic abuse. Now, Bill 168 really just required employers to have programs and procedures, and so recently, Bill 132 received royal assent. It's going to become law in September of 2016, and it looks specifically at workplace harassments and provides far greater requirements on employers to address sexual harassment and workplace sexual harassment, which are given a broader definition. In the tip sheet that I'll be sending you, I will provide you with information about Bill 132 and how you can comply when it does become law. And with respects to the answer to the question, all workplaces regulated by the Occupational Health and Safety Act must have a joint health and safety committee. That answer is in fact false, so the majority of you got it right, 67%. Joint health and safety committees are only required if you have up to 20 employees. If you have less than that, there is no requirement for the joint health and safety committee. As well, there are certain organizations that might have, even if they have less than 20, they would still be required to have a joint health and safety committee. But by and large, if you're a small workplace, you're not going to have the requirement to have a joint health and safety committee, although you still have to have health and safety policies. Now, this is another area that the ministry does target very carefully. They do have inspection blitzes that are going on now until the end of the year, and they target workplaces or economies that have a history of poor compliance with employee safety or work-related injuries. And the fines can be quite significant there, up to $25,000 for individual or $500,000 for a corporation, and in the case of individuals, up to 12 months of jail time. Now, I'm just going to quickly look at Workplace Safety and Insurance Board. And one of the things I realized when I was putting the slides together is that safety is one of those areas that there are probably a lot of questions. So again, if there is an interest in having some more information on the Occupational Health and Safety Act or the Workplace Safety and Insurance Act, please let me know. One thing about the Workplace Safety and Insurance Act that you should know is that it is a no-fault insurance system. So if an employee injures themselves at work or they have a work-related illness, they can obtain compensation within the Workplace Safety and Insurance Act. The regime provides for compensation. And so the employee gives away their ability to sue the employer directly or privately for any type of injury. And the employer who pays into that fund gets indemnity. Now, there are Schedule 1 and 2 employers that are listed in the legislation that are required to comply and provide and pay into the workplace safety and insurance regime, but other workplaces are not required to participate. And I have asked the poll question: which of the following workers are excluded from the Workplace Safety and Insurance Act? And if you can provide your answers now, that would be greatly appreciated. I'll be ending the poll very soon. Now, I'll say that with respects to employers who are not Schedule 1 or Schedule 2 employers, they can, in fact, participate in the workplace safety and insurance regime. So there is the ability to do that. Workers are broadly defined under the Workplace Safety Insurance Act, and actually independent contractors in construction are included in the definition, so they would be considered a worker. It's actually casual workers that are not that are excluded from the legislation. So all casual workers would not fall under the WSIA, but independent contractors in construction definitely would. In terms of enforcement, this is generally done by employers who are supposed to be part of the legislation, so Schedule 1 and 2 employers who haven't complied, and there are penalties. Within 10 days of hiring your first employee, if you are Schedule 1 and 2 employer, you must then register for WSIB. And the last area I want to look at is with respects to employee privacy. Now, this is one of those areas that I hear a lot, mostly from employees who feel that their privacy rights have been violated. Um, and I have a poll question. As an employer, I should say, can you search and monitor an employee's activity on a work-assigned laptop or cellular phone, even if the employee is permitted to use this device personally? So if you can go ahead and answer that poll question. So in Ontario, as I mentioned, there's no legislation, there's no statutory laws that govern or restrict or regulate the collection, use, disclosure, storage, or security of an employee's personal information in the workplace. The only exception would be the Personal Health and Information Protection Act, or FIPA. If an employee is providing information about their accommodation, let's say the employee is looking for, a workplace accommodation and they have a medical issue, or if the employee has had absences and they provided you with a note, the employee would be entitled to protections under FIPA that you can't necessarily share. They'd have an expectation of privacy with those particular medical records because you're not able to share those records. So that's the only statutory obligation that an employer has, and I would say a private sector employer has in Ontario with respects to privacy. However, the common law has been developing to provide greater protections for employees. One case that came to the Supreme Court in 2012 was an employee who had a laptop, and the laptop was used. It was a criminal case, so it wasn't necessarily an workplace case or employment law case, but the employee had used a laptop and had stored pictures of underage girls, which were basically against the law. It was basically child pornography, if you will. And the court did say that the employee would have an expectation of privacy with respects to that work-related computer, because oftentimes employees are able to use their work-related computers for personal use as well too. And that even though the computer belonged to the employer could not consent to being able to allow a police to just search this computer without a warrant. Recently, also, there was another case that established in Ontario that established some other or some greater guidance as to how there might be an invasion of privacy under the common law. It's called the intrusion upon seclusion. And essentially, it means that there's an invasion of private affairs without a lawful justification, and that it would be regarded as offensive. And so in some cases, it could very well be that search of an employee's laptop or phone could violate common laws, not statutory laws, but common laws. So in a way, that answer is true and false. Employers can search and monitor employees' activities on a laptop, but you would have to have guidance as to how you do that. The majority of you answered it true. And if you do say that it's true, hopefully you have workplace policies that enable you to do so. So looking at the cases, some guidance I give to my employer clients is that they need to balance the right and needs of their need for this to access the employee's data with the potential privacy rights of the employee. And principle of natural justice should always apply. So that means that you have to let employees know your reasons and know well in advance what the standard is. So if you're seeking to monitor employees, you should have clear written policies which have been signed off and agreed to by the employee. You should have a policy that establishes that employees don't have any expectation of privacy, and that their use, the use of the employer for the information on a laptop or notes or files, anything, could be used for performance, to conduct compliance audits, or also to monitor security. So can you search employees? Yes, make sure you have policies. A couple of things I will note about workplace privacy. Employees don't have a legal requirement to be able to access their files. So if an employee feels that they have a legal right to their file, that's considered an employer's records, and so employers don't have to disclose that. As well, that employers can monitor employees as well too. There's nothing inherently wrong with monitoring. There are restrictions though, and again, you'd want to have policies that basically allow for that. So we've gone a little over time, but what I'm going to do is see if there are any questions that have come through. I don't see any yet. If you do have questions, I will stay on the line and answer them. And I know there, like I said, there's a bit of a delay. So if there are questions, please put them in now. I will say that if there aren't any questions, I thank you very much for your time today. Our next webinar is in June. I know that time is the most precious resource that you can give. So I thank you very much for sharing it with me this morning. I hope you found this helpful, and I hope to see you again in June. You will get access to a replay with a tip sheet on Bill 132 and some other legislative changes that are helpful for you in your workplace. And I will stay online for a little bit if there are questions. If not, have a great day.